All right, well, good morning, everyone. Thank you for joining me early this morning and making it here. Like you said, some of us had extraordinary circumstances in getting here, and so I'm glad to see everyone this morning. The paper I've written, along with one of my good friends in Fort Worth, one of my colleagues, one of my adversaries at times, one of my co-counsel at some times, it's grown out of another paper we've written dealing with complex guardianship issues. So I think it's fair to say anyone who practices in the area of guardianship law can see that guardianships are rarely straightforward, rarely easy. They become complex because if you're dealing with a guardianship situation, you're dealing with potentially removing the rights of someone. You're dealing with family members who are not able for one reason or another to handle these issues, between or among themselves, and they're looking at you as the guardianship practitioner to help them, guide them in these difficult times. And as I've practiced in this area of the law, I've come to realize that guardianship can entail and bring in almost any sort of legal remedy, anything that's available. And it becomes rather messy. I used to pride myself on saying, oh, I don't do family law. Oh, and Shannon, Gracey, we do everything, but certainly not family law. That's not true, because if you're dealing with guardianships, you're dealing with family, you're dealing with emotions, and you're getting real close and down and dirty in people's business. And it's not always fun and not always easy. So we've put together this paper to try to present to you some of the more common remedies we've seen, some of them that we use, how to use them, and how to manage these kinds of situations. So we kind of start from the beginning. When someone comes in to see you and starts talking about their beloved family member and the changes that are occurring to them, where do you start? And if you're getting to that point in that situation, we always try to look at first, is it time and is it appropriate to consider a temporary guardianship? And it's not always the right time to do that. The Estates Code, now that we've been recodified from our beloved probate code to the Texas Estates Code, in Chapter 1251 of the Estates Code governs temporary guardianships. Temporary guardianships can be granted when you have an imminent danger to the physical health or safety or the estate of the proposed ward. And I have to be clear with potential clients who come see me, this is a true emergency situation. This is not, well, you have someone who's maybe making a bad situation or bad choice with money, or has maybe acted out inappropriately on one occasion. You really, truly have to have enough that you can go down to the judge with the jurisdiction in this matter, put on live testimony under oath, enough to convince that judge, as well as the ad litem attorney appointed to represent that proposed ward, that this is truly an imminent danger. Because if you were not to get this temporary guardianship granted, this ward would be harmed. I always start with giving the person who's applying for the temporary guardianship the form doctor's letter that's promulgated by the statute, because we need to have our medical evidence in place. We need to be able to show the judge that we do have medical danger, and I, as a guardianship practitioner, am not the one to determine what's medically in the board's best interest. So sometimes I'm able to kind of weed out the people who might or might not have the best interest of our proposed ward in mind, because if they're not going to be able to take the step of going to the doctor, getting the doctor to fill out the form doctor's letter, then I know that they're probably not interested in pursuing this temporary guardianship. However, the caveat to that, of course, is sometimes we're just not able to obtain medical evidence because of the ward's circumstances. The ward is not cooperating. The proposed ward has not been to the doctor in a long time, and that is quite often the case. If you have someone who's rather independent, someone who's not taking his or her medication, someone who's just refusing to go be examined and see the doctor on a regular basis, then of course we have a different story. In those circumstances, we can obtain a medical order for an independent evaluation from the probate judge. Again, we have to get enough evidence, though, sworn under oath, to say we must receive an evaluation ordered by the judge. The judge has the discretion to do that. So when I'm saying judge, let me be clear here. You know, every county has a different judge that has what we call probate jurisdiction of probate and guardianship matters. In some of our larger counties, we have statutory probate judges, and their jurisdiction is clear. They hear all matters related to probate and guardianships. Most of our smaller counties, it's either the county judge or the county court at law judge, so we need to check jurisdiction before you file, and I think those of us who practice in the smaller counties, we know which courts are which. But if something becomes contested, the jurisdiction can switch. It can move up to another level of court, and as I've found out recently in some of my counties to the west of Tarrant, where you think you might end up if you have a contested matter is not always quite true. You sometimes end up in a different court because of the special jurisdiction that those courts have carved out for themselves. So instead of being surprised to where you might end up if you have a contested case, you need to make sure you check your local rules always before filing or before you end up in a contested matter. So moving on, with temporary guardianships. Once you feel like you might satisfy the imminent danger, now, you know, years ago when I started practice in the mid-90s, we could obtain temporary guardianships without even notifying the proposed ward. That became kind of egregious, and some people were obtaining temporary guardianships not for the right reasons, not for the right purposes, taking control of the proposed ward's assets and not doing the right things. So the statute was changed, and we do have to notify the proposed ward anytime a temporary guardianship has been filed. So the proposed ward needs to know, and an attorney ad litem is appointed in all situations to represent the proposed ward when a temporary guardianship is filed. And those are the only two people that have to be notified of the temporary guardianship hearing. The temporary guardianship hearing is supposed to take precedent over all other matters of the judge with the jurisdiction to hear that matter. So I've had, unfortunately, some circumstances where I have to remind the judges in some of our counties who don't hear these things quite often that I really have an emergency here. Please put this on your calendar as quickly as possible, because I've had some of them schedule them, you know, 3 or 4 weeks out down the road, and by that time, honestly, I could have had a permanent guardianship heard, and my need for temporary would no longer be needed. So we just remind your judge or your judge's assistant at that point of the urgency to have your temporary guardianship heard if you're in a county that doesn't always hear temporary guardianships on a regular basis. Your order granting your temporary guardianship must clearly state the powers granted to your temporary guardian. You can't have a blanket order that says, my temporary guardian has full authority to do all powers are listed in the estates code, like we sometimes do when we're granting a permanent guardian, because the whole purpose of this remedy is to grant only the powers specifically needed to protect that ward during this temporary guardianship. So very clear and tailor your powers to what is needed in that situation. And just like in a permanent guardianship, you need to get a bond, you need to have an oath, and you need to have your bond approved, I suggest, at the same time you have your temporary guardianship hearing. So if you're going to practice regularly in this area of law, it's really a good idea to develop a relationship with a bonding agent who can meet you at the courthouse when you're going to get your guardianship in place. So you can have your oath and your bond signed right there, go down and get your letters of temporary guardianship, and have your temporary guardian go on his or her way to collecting your assets and taking care of your proposed ward, getting him or her out of that dangerous situation. And just like your permanent guardian, the only thing a temporary guardian can do without court approval is pay your bond premium, pay taxes, and insure assets of the ward. Your temporary guardianship stays in place for 60 days unless extended by a contest. So at that point, if you have another family member who knows of the temporary guardianship being granted, comes in and files a contest and says, hey, I'd rather become permanent guardian of mom, you can have this temporary guardianship extended during the contest and until the permanent guardian is in place. So, what I have found, though, in our days now that we have electronic filing, and most of our counties are going to mandatory electronic filing of all of our pleadings, it's a little more difficult to obtain a temporary guardianship without notice to other parties, especially if you have someone checking our filings, checking the probate filings on a regular basis. So sometimes the other party, the bad son, the bad daughter who might be causing the need for this temporary guardianship does know of the temporary guardian hearing before you're able to obtain the letters of temporary guardianship. So what if someone shows up to your temporary guardianship hearing and objects or files a contest? What's going to happen then? Well, you can still have a contested guardianship hearing. If someone files an objection, it's going to be up to the judge to decide who's the best choice as temporary guardian. A lot of times, judges will just simply punt and appoint a third-party guardian as a professional guardian as temporary guardian to sort out the issues and just kind of be a neutral party, step back while both contestants to the guardianship fight it out until a permanent solution can be raised. And a couple of times lately, really within the last couple of years, I have actually been appointed as an ad litem for a proposed ward in a temporary guardianship, and for the sole purpose of objecting to the temporary guardianship on behalf of the ward, because in my opinion, and in the proposed ward's opinion, a temporary guardianship was not the best thing for this proposed ward. It was filed, in our opinion, by a family member who was really just trying to gain control of the proposed ward's asset or the proposed ward. And again, that's really a good reason that we now have to have an ad litem appointed before a temporary guardianship is granted. So we went to court and had a little trial, and then in that case, put the proposed ward on the stand, who looked right at the judge and said, hey, I don't need a guardian. I'm doing just fine. So, temporary guardianship is a good remedy in some situations, but again, the proposed ward has the right to object, and if you find yourself as an ad litem or as the party representing the party who thinks it's not a good choice for the proposed ward at that time, you can always bring your proposed ward to court and have her day in court. All the judges are always accommodating of the proposed ward in those situations. I was talking with one of my colleagues as we were flying down when we were able to get on the plane yesterday about mental illness, seeing that in regard to temporary guardianships lately. And I'll just digress briefly because at least our courts in Tarrant County, but I think it's probably consistent with most other courts in Texas, that temporary guardianship is really not a good method for dealing with people who are purely suffering from mental illness, just because the nature of a guardianship is not such that it's a good way of dealing with the cycle of mental illness. But that said, I still get several calls every month about an awful and terrible family situation where mom is just not taking care of herself. She's not taking her prescribed medications. She's a danger to herself. She's running around. I can't control her. But Adult Protective Services has come out and said she's okay. I've called the police, and they've detained her on a mental warrant, but they've let her go after the prescribed period. And, what can we do? And it's a really difficult and terrible situation. And, after years of trying to work with our probate courts on this, the only answer I've been able to come up with is if, in those situations where you have someone struggling with mental illness, and you really do have a diagnosis of mental illness, if you're able to get a diagnosis of something else in addition to mental illness, and that requires, of course, someone filling out a doctor's letter, a dementia or something else, perhaps you're able to work through the guardianship situation in that regard. But otherwise, it's not always a good fit for the guardianship process because of the nature of mental illness and the cycles that they go through. And it's sometimes bad news to have to give to a client. But what I understand is our courts just aren't able to really keep opening and closing guardianships in those situations because, as I understand, people with some sorts of mental illness are able to recover to the point that you're able to restore them to their full functioning ability and close the guardianships. And then, unfortunately, they'll get to the point where they can cycle back and you may have to open the guardianship again. So I wanted to pass that along because I know if I'm seeing this in my practice a lot, I know that others are too. Okay, moving on to restraining orders and injunctions. I've had a few instances in my practice where I've been requested and it's been an appropriate time to obtain a restraining order and perhaps move that along to an injunction in connection with a guardianship. But it's just been a few times because the nature of a restraining order is, so restrictive. So let me point out, though, the most obvious, I guess, point is there has to be some sort of underlying lawsuit connected to an application to obtain a restraining order in the probate court in connection with a guardianship. So, of course, you need to have a guardianship application on file first, and then a request for a restraining order. And usually in Texas, if we're filing a restraining order, we will connect that with a request for a temporary injunction. So the other side of that is when you get phone calls saying, I want to get a restraining order for this. You see a lot of people who've spent some time watching TV shows like Law & Order who think you can just go on out and get a restraining order for whatever reason. You need to be sure and vet out the exact reasons that they're looking for that and make sure that there's some sort of underlying lawsuit, because you're not going to be able just to go out and apply for a restraining order without any sort of underlying relief in place. In the guardianship context, obviously, if we're talking about a restraining order, you're looking at the person applying for the guardianship, obviously then trying to restrain some other party, some other family member from doing some sort of harm to mom or mom's property. And those have been the context in which I've received and applied for a restraining order. In that case, the restraining order is governed by the rules of the Texas Rule of Civil Procedure. Verified application, immediate and irreparable harm and injury are going to occur to in this case, the proposed ward or the ward under the guardianship. And you must obtain this restraining order before notice can be given to the party you're seeking to restrain. This type of restraining order can stay in place 14 days unless extended by a temporary injunction. Again, a bond must be posted as ordered by the judge granting the restraining order. And it's different from the corporate surety bond that you obtain in your guardianship proceeding, because the bond is posted by the applicant applying for the restraining order, and it's actually in favor of the person being restrained. And it's your responsibility as the attorney for the applicant to make sure that all of these steps are in place. The bond, the order, it's all granted, and the bond is correct, because you can't, like I said, it's not just your corporate surety bond that you're used to obtaining in your normal guardianship practice. Once you get all that in place, the writ of the restraining order or the writ of the temporary injunction is issued by the clerk of the court served on the person being restrained. If any of those things are not done, the restraining order, the injunction, can be dissolved. And that would be a sad day for you and your client if none of these steps, one of these steps was missing and then that restraining order was dissolved. So what kind of things would we be restraining or in this type of guardianship situation? Like I said, someone from visiting the ward. It'd have to be pretty egregious, and that's the type of context that I handled it in, because as a guardian in Texas, you're already able to prohibit someone from visiting the ward. So it'd have to be someone who, despite your attempts as guardian to bar this person from visiting the ward, is just not complying. The context I handled it in is I was guardian ad litem for a man under guardianship, and the brother had taken his money, who was the guardian. And so I filed a removal action to remove that man as guardian, and then I was restraining the man from visiting and having access to any more money. The other context we've seen it in is from going after other money of the ward that's not under the guardian's control. Assets in a revocable trust, perhaps, something that you as guardian don't have access to because it's in a different vehicle, those kinds of things. So it's a pretty, if you look at it in that context, a broad remedy, because if the judge can reach out and restrain that, that's getting a hold of other assets and restraining the person from going after them. And as we all know, a restraining order can move to a temporary injunction and then to a permanent injunction as well. Service. I wanted to kind of touch on some things I've seen on service, in connection with restraining orders and backing up to service on a temporary guardianship. But of course, this can apply to service in general in guardianships or any other situation. The appellate court has ruled that substituted service is acceptable, specifically in temporary guardianships. And this was a case that I had. I had an older lady who had one son, and he lived in a different state, but she had become susceptible and under the guise, so to speak, of a man from a different country who started moving in on her and getting access to her funds. She said she was in love with him and she wanted to marry him, even though he was several decades younger than her and of a different nationality. And he'd been married and divorced and had younger children of his own. He was really doing some egregious things with her assets and, taking control over hundreds of thousands of dollars. And I had been appointed by the court as guardian ad litem to kind of straighten out what was going on. And when I was able to get access to the bank records and see what was happening, I filed for an application for a temporary guardian for her as well as a permanent guardian. And I was trying to get her served. The problem was, when a constable comes to someone's house, because at this point she was still living independently, she kind of caught on to what was going on. She wasn't opening the door, and this man was there and not allowing the door to be opened. So I asked for service by a private process server, because after the service with the constable was not successful, we're able to do that. In our probate courts in Tarrant County, anytime you serve with a private process server, you do need to get an order signed by the judge. And we used to at that point have a standing order for one certain private process server. Now we need to get that order signed each time. So if you're going to serve with a private process server, make sure you check your requirements of the court you're using. Went through that process, and that requires, an order, a motion and an order being signed. At this point, it's taking time to get this lady served. So I go down that route. And the private process server I use, he just looks like you and me. He wears a nice suit, he has an overcoat, he wears a hat. He looks like someone just coming to your front door. She wouldn't open the door to him either. So she knew she was catching on, or the friend was catching on as to what was going on. So, after several attempts of that, the only thing that was left was substituted service. Again, a separate motion and order, is required. At this point, my temporary guardianship, could have and should have been granted, but we spent several days trying to get this nice lady served. And the irony was, my private process server, she had opened the door to him, and he had seen her, and he had told her what he was trying to do, and she just said no. So substituted service was the only way that I could go. And after doing that, he opened the door and threw it at her, basically. And then the attorney for the man who was ultimately forced to give back the money he had taken argued that she was never served properly because substituted service is not an acceptable form of serving in a temporary guardianship. But after all of that, just the short answer is it is. So if that's the last thing you need to do to get someone served in a temporary guardianship, it is allowed. And even to the point of having your private process server come to court to testify that he accomplished service, if that's what needs to be done. All right, receivership. I consider receivership a less restrictive alternative to a guardian of an estate. And I use this a few times when I really have a specific task that needs to be accomplished. If I have an incapacitated person who has a guardian of the person and might just have a piece of real property that needs to be sold. And I know that this estates code allows property under $100,000 to be sold, without any sort of proceeding. You can sell that and put the assets in the registry of the court. So I always use that, if that's an appropriate remedy. But receivership is a statute that's specific to guardianships. There is a comparable statute, in the rules of civil procedure, but it's a little more complicated. So if you have this guardianship type situation, keep it in mind because there's no dollar limit. So you can use it when your real property is over $100,000. But the beauty of this statute is your receiver doesn't have to be a private professional guardian. So I've used it because we have a couple of people in town who are great real estate people. And they have contacts, and they can get these little pieces, these houses sold quickly. They can get 2 or 3 bidders bidding against each other and get a high price. And then the beauty of this is they can sell the house, and then they can use the proceeds to pay some of the expenses associated with the cost of the receivership and some of the expenses associated with the ward. And that cannot happen if you're selling the property under that statute and putting it in the registry of the court, because anytime you put money into the registry of the court, you need to, in order to get it out, it requires a motion and order from the court and, of course, a bond to be put in place. So keep that in mind and use the receivership when appropriate because it's a useful tool. And like I said, you don't need a private professional guardian because in most of our guardianships of the estates now, if it's not a family member, you're going to need to have a private professional guardian, and they're going to charge as well to do that. All right, moving on to transfer. I have seen so many more transfers of guardianships in the last few years than I have seen altogether in the prior 10 years, and I guess the reason for that is we just have a much more mobile society. And that's a good thing. We have a lot of people moving to Texas, so due to our good economy. And then we have a lot of guardians and wards wanting to establish here. So I am pleased to say, honestly, we're finally getting the guardian transfership statutes. They've become a lot easier to use. And transferring a guardianship is not as difficult as it has been in years past. And that's a good thing. Years ago, I'm talking about a decade ago, it was almost easier to really, if you had a ward from out of state moving to Texas, it was almost easier just to start over, quite frankly. But the statute now has made it much easier to transfer an out-of-state guardianship here to Texas. You still have to file an application, but you don't need an ad litem, and you don't need medical evidence, obviously, because the ward has already been declared incapacitated. And the statute is clear. You must give full faith and credit to the guardianship or conservatorship established in the other state. Now, some of our courts will, depending on the procedure in that court, once you do file an application to transfer, the policy of that court may be to appoint a court visitor to visit with the ward who's moving to Texas and to visit with the guardian. So you could need to know, your policies, obviously, in the court that you're working with. But some counties don't do that. So I've seen it both ways. Some make it real easy. Some make it a little more difficult. But how it's become very easy is we've done away with the need to get the exemplified copies of the court proceeding, in the state that we're transferring from, because I think we all know that we've seen problems with trying to obtain exemplified copies, which is the copy of the document signed by the clerk, signed by the judge, and then signed again by the clerk, signifying that the judge signed the document with the ribbon and the seal and all of that. And if that's not done properly, then you have to go back and call again and make sure that it's done and sent again. So now it's just a certified copy, which is wonderful. Still have to have, your oath, your order, your Texas bond, and you're going to have to comply with all of the same annual requirements we have here in Texas. You have a guardian of the estate and annual accounting and all of that. So in that respect, you're just kind of starting over in Texas, but that's all right. What is unique and is good is it's a good time to examine what was in place in the other state and see how that works in Texas and how that will work with the needs of the ward moving to Texas. Because what if you don't have a full guardianship in the state you're transferring from, and you do need a full guardianship here in Texas? Or some of the powers granted in your other state don't work here or are too restrictive. You can use that almost as a way to modify what you're doing in Texas. Or, as I've seen often in other states, most recently, I think it was Illinois, I had 3 co-guardians for one incapacitated adult young man, and it was his mother and 2 of his sisters. And as we all know in Texas, we can't have that. Only time we can have co-guardians are if it's husband and wife for the 2 parents for the child. So I had to explain that we need to pick who was going to be the guardian here in Texas. But the interesting thing is, when you're transferring from the other state to Texas, you're transferring it as to who's the guardian. So what we did is we transferred the 3 co-guardians here in Texas, and then we had the 2 resign immediately in connection with the transfer, because you can only have the one in Texas. And honestly, it was probably the best, because the mother, who was older, was not going to look after the son anymore. And then the reason that ward was transferring to Texas was to be near the sister who lives here. So the sister was the obvious choice as guardian here. We have another new statute similar to the transfer, and it's actually in section 1252 of the Estates Code. It is the appointment of a non-resident guardian for a non-resident ward. So it's a similar situation as a transfer, but a very limited purpose. And the instance I'm seeing this is if you have, the only reason your connection is here to Texas is real property located here in Texas. And the only reason you would appoint that non-resident guardian over a non-resident ward is here in Texas to sell the real property located here in Texas, a very specific purpose. And I am working through that right now. However, the statute's a little different than what a transfer is, because it doesn't say anything about full faith and credit, even though I'm pretty sure that was the intention. And I don't expect an ad litem should have been appointed, although I got an ad litem appointed, and my ad litem is giving me some grief about what the statute says. So I'm working through it. It's my understanding, though, in that situation, by reading back as to what the intention was on the statute, it's really similar to an ancillary probate. It's forced to be a specific use for that statute to allow, in this case, I would expect to sell real property, and you're not supposed to go through the whole incapacity kind of situation. So I'm thinking we might have to review that next legislative session in a couple of years. We've also used turnover as a very special remedy. Somewhat people in my office have used it. I personally have not used it. I know my co-author, Deanne McCulley, has used this when you have a guardian who, yes, we all know, is entitled to assets of the ward, paper, property, anything of the ward to come into your control as the guardian. And in fact, it's a duty. You are to take possession of anything coming to the ward, but for whatever reason, you're not able to do so. We've provided the forms to do that, and cited the case, the Hutchins case, which, although it applies to turnover order in an estate, I think you can look at this comparable statute in the Estates Code dealing with guardianship and apply that. I wanted to touch briefly on removal. and let you know that although in years past, I would say as practitioners, we've done more removal without notice to the guardian being removed. I believe now most courts are going to require notice be given to the guardian before removal can be done. Just because there's been a lot more publicity about guardians being removed without receiving notice. And so I'll let you know, we've cited the statute that if a guardian is removed without notice, that guardian does have the ability to come back and seek reinstatement after receiving notice of removal. We've provided the forms, though, as to how to go about the process of removing. But it's a removal notice, a removal hearing is going to require evidence of gross misconduct and failing to maintain the ward, failing to or about to misapplying or embezzling or about to misapply or embezzle the assets of the ward. You're going to have an ad litem appointed to investigate this, and if you're removing without notice, the standard is clear and convincing evidence. It's a good idea, if you're going to file a removal action, to accompany that with an application to appoint a successor guardian, because it just doesn't make sense to remove a guardian and then have no one in place to take over. So consider who's going to be in place, obviously, to take over as the guardian is removed, and consider that person's ability to qualify as successor guardian, and don't omit anything that the proposed ward put in place about his or her choice as guardian. Look at the designation of guardian that the proposed ward made. If I'm incapacitated, who's my guardian choice going to be? Make sure that they can qualify for a bond, the corporate surety bond, and the amount of the assets. Make sure that they're not going to be kicked out for an adverse interest. I've seen this tool being used a lot lately, and I think it's just the nature of guardianship cases becoming more contested. We have been using motions in limine as a way to try to kick out an adverse party to a contested guardianship for a lack of standing before the guardianship case gets moving down the track. And a motion in limine in this regard is different from the standard motion in limine you'll use in a regular trial setting, where everybody tries to exclude evidence before the trial moves forward, comes up to the judge and will remind the judge during trial. That was excluded during the motion in limine. This is a motion in limine on standing issue, and it's filed by one party against another to say this applicant to this guardianship proceeding has a lack of standing and needs to be removed from the case. It's a powerful tool, and we need to keep that in mind. We've touched on that in another paper, and I want to talk about that. We've also included mandamus, and I'll just point out to you, I've never used it just because I'm probably too scared to file a mandamus against any of the judges, but it is available in guardianship context as well. The case law on guardianships on mandamus, very limited, but it is available, and if any of you use it, please let me know. Well, thank you. We're out of time. Oh.